Hello and good morning, friends. Welcome to CEC Live Lectures. Dear friends, today we would be continuing further within our series on copyrights. Dear friends, today we would be talking on rights under copyright law. Dear friends, as you know that we have discussion on the respective topic in our previous session also. So we would be starting from the point where we left in the previous session and would be discussing more on rights under copyright law. So we would say that this is the second session on the following topic. Friends, for this discussion we have once again with us within our studios Mr. Ashwini Sibal. Mr. Ashwini Sibal is Assistant Professor in Faculty of Law, University of Delhi. Mr. Sibal has immense experience and he is continuously contributing in the area of academics. He is appreciated by the students for his dint of knowledge as well as his ability to exchange information and knowledge very efficiently. If you want to ask questions from Mr. Ashwini Sibal on today's topic, then you can contact us through our toll-free number. Our number is 1800-110-430. I repeat, our number is 1800-110-430. You are requested to call in the last 10 minutes of the lecture so that first you could have a deep insight into today's topic, and yes, at last we promise to give answers to your questions through Mr. Sibal. So we would like to welcome our guest Mr. Ashwini Sibal, and let's try to have a productive session once again. Hello sir, welcome to the lecture.
Hello, Ritika. Good morning, friends. I believe all my viewers remember that we have discussed in the previous session different rights under the copyright law, but we have not concluded all those rights. We are supposed to discuss few more important rights of the copyright owner in our today's discourse. Well, friends, we have seen in the previous discussion very important rights in relation to the owners of the copyright, which are called the fundamental rights of a person owning the copyright. And these rights emanate basically from Copyright Act 1957. The rights are provided under Section 14 of the Copyright Act 1957. My dear friends, we have seen the right to reproduce the work in our previous discussion. We have seen that the right of reproduction of the copyrighted work lies exclusively with the owner of the copyright. We have seen the right of issuance of the work to the public, not copies already in circulation. Well, my dear friends, as far as the right to issue copies to the public not already in circulation is concerned, it is one of the important rights, and in recent past there had been a lot of debate and discussion as far as this right is concerned. Since this right has been provided in a very different, or you can say in a unique sense, under Section 14, wherein in the later limb of this right, there is a limitation provided. My dear friends, that limitation basically or explicitly wants to limit or curtail the right of issuance of the person to the public. The right lies with the owner to issue the work to the public, but it is a one-time right, because the later limb of the provision reads that the right is available to the person only to that work which has not come to the circulation. So once the work has come to the circulation, the right goes away or it vanishes. I have discussed with you this important right in my previous discussion. And my dear friends, I have also highlighted that in the recent past we had two important cases on this aspect. One was John Wiley versus Prabhat Chandra. Another case was also of the similar appellant or similar plaintiff John Wiley, but that was decided ex parte by Justice Ravindra Bhatt, pronounced by Justice Ravindra Bhatt in Delhi High Court. Well, my dear friends, as far as the case in relation to issuance of the work to the public is concerned, it has been said by the Justice Manmohan Singh in the first case in relation to John Wiley versus Prabhat Chandra, or in the case of John Wiley versus Prabhat Chandra, in the matter of John Wiley versus Prabhat Chandra, in relation to the issue of issuance of the work to the public, that this right in that particular case or in the facts of that case has not been exhausted by the owner of the copyright, and the publishers were given the relief by Justice Manmohan Singh, which was heavily criticized, my dear friends, by the academia and by the judiciary itself. And there had come many writings criticizing that judgment, because the judgment read export in the copyright law when the word export is nowhere used in the Copyright Act or in any of the statutes of the intellectual property in India. The word export has not been made infringement in any of the statutes of the copyright, or has not been made, infringement in any of the statutes of intellectual property in India. But in that case, the judge said that the export or the act of exporting the copies which were legitimately bought by the respondent in that case, they were sent or exported by that respondent to the foreign country, right? But the court said that this act of exporting that copy or those copies which were legitimately bought by the respondent will tantamount to infringement. This is where the judge went wrong, my dear friends, and has been criticized heavily, that this should not be the law, because copyright law cannot be applied on the exports of the works. It only makes import of infringing copy infringement. It does not make export of infringing copies infringement. So my dear friends, we have understood in the previous discussion that issuance of the work to the public, not already the work in the circulation, is a very limited right or a one-time right. So the owners in John Wiley, they have already exhausted, or they were found to have been exhausted their right of issuance of the work. Once they had issued their work, they had no control or further control on the distribution of the work. So what Mr. Prabhat Chandra, the respondent in that case, was doing, he was just issuing the legitimate copies bought legitimately by him. But the twist of the matter, or you can say the catch in the matter, was that those copies were meant to be sold only in stipulated countries. Those copies were low price edition copies to be sold only in few nations like Bangladesh, Bhutan, India, etc. But the publisher, made their legitimate distributor, authorized distributor, for selling those copies in countries, stipulated countries like India, Bhutan, Pakistan, Afghanistan, etc. But Prabhat Chandra bought those copies from the legitimate source in India and started shipping those copies to different nations, and the free shipment was also offered by Prabhat Chandra on his portal for selling those low price editions which are meant to be sold only in few nations, which are stipulated nations, on the first cover page of the book, and those books were meant to be sold only on those nations. This is where he went wrong. But copyright law cannot be invoked, my dear friends, to restrict the act of this infringer or alleged accused. In this case, there might be invocation of some other acts. Import-export laws can be invoked to stop such kind of a transition or transaction, but copyright law cannot be invoked. So the court was, little deviated in so far as this case is concerned. We have already discussed it. Now I have to take you to another important rights which are provided under the copyright law to the owner of the copyright. These are as follows, my dear friends. Reproduction is one right. Issuance of the copies to the public is another right. Then there comes the right of performance in the public or communication of the work to the public. I might have told you that performance to the public is the prerogative of the owner of the copyright. Even the communication of the work to the public is the prerogative of the owner of the copyright. So nobody else can communicate or perform the work to the public. If somebody is performing or communicating the work to the private sphere or to the family or to the friends or for his private entertainment, if he is performing the work without the authorization of the owner of the copyright, it is fine. No liability would accrue to that person and he or she cannot be made liable. Then there comes another important right, my dear friends. It is to make cinematograph film or signed recording in respect of the work. So making a cine film of the copyrighted stuff is also the privilege or prerogative or the right provided to the owner of the copyright by purview of the Copyright Act. Then there comes the next right, my dear friends. It is to make translation of the work. I might have told you in my discussions that translating the work into another language, into other languages, is also the right conferred to the owner of the copyright or to the creator of the work. The one who has created the work, it is only to him that this right of translating the work lies. No other person can translate without the prior authorization from the owner of the person. Then there comes another right, my dear friends. It is called to make an adaptation of the work. It is one of the important rights and very hotly debated and discussed. And the law relating to adaptation, or you can say on to different aspects of adaptations, is well settled. And we have a number of cases, or we have good textbooks which may be referred to understand as to what adaptation mean and how the right of adaptation can be exploited and exercised by the owner of the copyright once he conferred with the right of the copyright, or once he creates the work. This is the most important right. I will discuss on the right of adaptation in my later slides. Before that, I would like to complete the different rights available to the person under section 14. And the next and the last right, my dear friends, in relation to the owner of the copyright is the right to do any of these above mentioned acts. Above mentioned acts means all these acts mentioned under clause 1 to 6. All these acts can be done even with the translated or the work which has been given a different format by adaptation. So, you see, one who is confused as far as the meaning of bundle of rights is concerned, so I believe this is the opportunity for that reader or that viewer to understand that since there are already 6 rights given in the main language of section 14, but in the 7th clause of section 14 you find the rights are multiplying, because even on the translated work the preceding 6 rights are available. Even on the work which is a outcome of the adaptation, all the preceding rights are available. So this is the reason that it is called that copyright comes with bundle of rights, and many rights available with the copyright. Well, my dear friends, let us move ahead and see in the cases of computer programs what are the rights available to the person. As I have discussed in the very beginning when I started discussing about the rights in the cases of copyright, that there are several economic rights available to the person under the copyright, and the rights or the conferment of the rights varies with the nature of the work or with the categories of the work. In the cases of literary, artistic, dramatic work, we have just seen that there are several rights available, bundle of rights are available. In the cases of computer programs, my dear friends, all those rights which we have seen under clause A are very well available. I mean the right to reproduce, right to translate, right of adaptation, right of communication, performance, right to issue copies to the public not already in the circulation. All those rights are available in the cases of the computer program. Additionally, there are few more rights with this category that may get conferred on a person after obtaining the copyright on a computer program. These are popularly known as commercial rental rights. See, the nature of the program, computer program, or you can say the nature of the work here is little different from the works which we have discussed previously. We have discussed works which are literary, artistic, dramatic works, but here we are now confronted with the question of discussion on computer programs. So in the cases of computer programs, the rights have to vary because the nature is such which requires conferment of some unique kind of rights. Because of the fact that computer programs, or in view of the fact that the computer programs can be easily imitated, can be easily copied in nowadays, when we have seen the exponential increase in the use of the computer, or you can say computer programs, by the common people. So in light of that, commercial rental right is also available. This is an additional right and a unique kind of a right available with computer programs. It was not available with the previous works which I have just discussed with you. It was not available with literary work, with dramatic work, with artistic works, but it is available with what? With computer programs. And the rationale or the logic that can be given in order to substantiate this point or this reasoning is that the nature is such which requires the conferment of a unique kind of a right. So if somebody owns a computer program and if he has got the copyright protection on that computer program, well, my dear friends, those of you who are wondering that how can computer program be given a copyright protection, let me make it very clear that computer programs are protectable under the copyright law. They are not protectable under the Patents Act. Patents Act is providing, you see, protection to certain things which are related to computers, but computer programs per se are not patentable under Patents Act of 1970. Computer programs can be given the protection under the intellectual property, but they are given the protection through the copyright law, not through the Patents Act. So it is very clear for you to understand that computer programs comes under the category of literary works as far as copyright is concerned, and they can be very well given the conferment of the copyright. And the additional kind of a right that is available apart from the normal rights which are available with literary, artistic, dramatic works is the right that is called rental right. So if you own a computer program, if you are giving it to somebody, you may charge the rent, or you may offer your computer program to be given to someone on a commercial rental. It is a unique kind of a right. If you have a literary work, you see, there is no right available in the case of a literary work which empowers the owner of the literary work to give the work on a commercial rental. So is the case of artistic work, so is the case of dramatic work. But here, in the cases of the computer program, rental rights are available and can be much exploited by the owners of the computer programs. Now, you see, there is the last thing that I would like to emphasize. There is a proviso in the act which is attached with the computer programs. It reads that provided that such commercial rental does not apply in respect of a computer programs where the program itself is not the essential object of the rental. So you get the rental right only in what situation? You get the rental right when, in your transaction to rent out something, you are renting the computer program as such. If the computer program as such is not part of your rental activity, you may not be able to exploit or exercise your rental right, my dear friends. So kindly take care of the proviso attached and do exploit your right, which is called rental right, apart from other preceding rights which are emanating under section 14(1)(a). Now let us move ahead and see another category. In the case of artistic works, my dear friends, there are few rights available which are called the right to reproduce the work in any material form, including depiction of the artistic work in 3-dimensional of a 2-dimensional work, or in 2 dimensions of a 3-dimensional work. See, artistic works are the subject matters of the copyright. On the artistic works, copyright can be conferred. There must be no confusion to the viewers as far as this aspect is concerned. With the artistic work, you get a right to reproduce the work in a 3-dimensional form. If it is in a 2-dimensional form, you may reproduce your work into 3-dimensional form. If it is in a 3-dimensional work, you may reproduce your work in 2 dimensionals. So it is up to the owner of the artistic work to convert your work into this manner as written here. Apart from that, the right of communication of the work also lies with the owner of the artistic work. Right to issue copies of the work also lies with the artistic work owner. It is another right which is called inclusion of the work in cinefilm. Well, my dear friends, as far as this 4th clause on your screen is concerned, it is interesting to note that inclusion of the artistic work is the right of the owner of the copyright. If I would like to exemplify it, my dear friends, I would like to take an example of the cinefilm, wherein you see, during the making of the film or during the video recording of the film, if there is one artistic work which happens to be a part of this cinefilm, video recording, or you see that act of video recording made by the producer or the director of that film, that artistic work or the inclusion of that artistic work should not be made by the director of that cinefilm or the maker of that cinefilm without the prior authorization from the owner of the artistic work. To elaborate the example further, suppose there is a work of M.F. Hussain. That work cannot be included in a cinefilm without the prior authorization from the owner, who is M.F. Hussain in this case. If his artistic work accidentally happens to be a part of cinefilm, then in that case, the owner of that artistic work can institute the action of infringement against the makers of that cinefilm because they have included his artistic work without his prior authorization into cinefilms. That cannot be done because it is the prerogative or the right given to the owner of the artistic work to include the work into a cinefilm or to allow or authorize somebody to include that artistic work in a cinefilm. I believe you have understood this idea or this concept. Now let us move ahead and see another right, that is called to make an adaptation of the work. I have promised you to discuss in detail the right of adaptation in the end, so I'll take it up later. Then the final right in the cases of artistic work is the right which multiplies or which gives the opportunity to multiply all the preceding rights mentioned here. Now moving ahead, in the cases of cinefilms, my dear friends, another category which is also a subject matter of copyright, and copyright can be conferred on cinefilms. The rights are as follows: to make a copy of the film including a photograph of any image forming part thereof. Well, my dear friends, it is a very unique kind of a right mentioned here. To make a copy of the film is the right of the owner of the cinefilm, and you see it further reads including a photograph of any image forming part thereof. So if the director of the movie, one who claims authorship on that movie or on that cinefilm, on that work, if he wants to cut his cinefilm and makes photographs of that film or the images of that film shooted by him, it is his prerogative to do that. Nobody else can even claim a right on the photograph of the image of the cinefilm. If I am appearing on your screen right now, my dear friends, it is a cinefilm getting recorded here, or it is a video recording getting recorded here. So if you take an image from the screen in front of you and claims a copyright on the photograph clicked by you of that image, you may never be able to claim authorship or the copyright on that, because as per this language written here, in the case of cinefilms, the right to make a copy of a cinefilm including a photograph of the image of any part thereof is the right of the owner of the copyright. So it is only him, the owner of the copyright on a cinefilm, can make use of the images or can claim the copyright on the photograph of the images taken by him. Nobody else can do that. Well, the another right, which is again a unique kind of a right available in the case of a cinefilm, my dear friends, is to sell or to give on hire or offer for sale or hire any copy of the film, regardless of whether such copy has been sold or given on hire on earlier occasions. Well, my dear friends, this is a different or unique kind of a right available only with this, not only with this category, rather this right has appeared even with this computer programs earlier. So only with the two kinds of works, one with the computer programs and the second is with the cinefilms, the right to give on hire or on commercial rental lies, not with the rest of the subject matters of the copyright. We all know that there are different subject matters of the copyright. We know that literary works, artistic works, dramatic works, cinefilms, sound recordings, etc. are the subject matters of the copyright. But you see, my dear friends, the right on making available your work for hire or on rent lies only with the two kinds of the works or the two subject matters of the copyright, which are cinefilms, one, and computer programs is the second and the last. The right of rental or to give the work on commercial rental does not lie with rest of the works or with rest of the categories of the copyright. Well, now move ahead and see what other rights are available in the cases of cinefilms. To communicate the work or the film to the public is the prerogative of the owner of the copyright, and it is the right of the copyright owner to exercise this right of communicating it to the public. That's all about the cinefilm. Now coming to the next category or next subject matter, that is called sound recording. There are several rights available even in the cases of sound recording, which is again a subject matter of the copyright. What are those rights? To make any other sound recording embodying it. If you have made a sound recording you can make use of your sound recording and make another sound recording embodying your previous sound recording. This is your prerogative or the prerogative of the owner of the copyright to sell or give on hire or offer for sale or hire any copy of the sound recording, regardless of whether such copy has been sold or given on hire on earlier occasions. Well, my dear friends, I have been wrong in making a statement that the right of making the work available on hire or on rental lies with only two works. It lies basically with the three works, and I'm sure that this lies only with the three works. The sound recording is another subject matter with which the right of rental or making it available on hire is available, along with cinefilms and computer programs. So I make a clarification here for the viewers that the right of leaving your copy on hire or making it available for hire and on giving it on a commercial rental is available with the sound recording, with the cinefilms, as well as with the computer programs. Three things now. Now the next kind of a right that is available to the category called sound recording is the right to communicate the sound recording to the public. It is your prerogative to make it available to the public. For the purposes of this section, there is an explanation attached here which reads, a copy which has been sold once shall be deemed to be a copy already in circulation, which I believe we all understand by referring to the first sale doctrine. We have discussed the first sale doctrine while discussing the right called issue copies to the public, not copies already in circulation. So this explanation is just to make it clear and to reiterate the point that copies which have come to the circulation by purview of sale, they will also be deemed as copies in circulation. Well, as far as this part is concerned, my dear friends, I have discussed in detail different rights available to the person which are called economic rights of the owners of the copyright provided by purview of section 14 of the copyright, and we have seen them in detail except on one part which I am going to discuss very soon, that is called right of adaptation, with a very relevant case law and with the very relevant principle propounded in that case law in 1924. In that case, my dear friends, I will be elaborating upon the important aspect of making the adaptation and what does adaptation mean. I will be referring to important textbooks as well. But before that, in the next session, I will be first emphasizing or first discussing the aspect called moral rights. I will be discussing what are the moral rights of the authors. We have just seen the rights which are called economic rights, wherein we have seen in certain categories rental rights are also available. But in the next session, I am going to discuss the moral rights of the owners, and the moral rights are of very huge importance nowadays, because in the recent past we have seen the judgments delivered in different jurisdictions of the world emphasizing on the importance of the moral rights of the owners of the copyright or of the authors of the copyright. So I will be discussing the moral rights immediately after this section, my dear friends.
With this note, thank you, sir. Thank you so very much for giving us the session. And friends, we want you to be with us as we are going to be back after a few minutes. Welcome back, friends. Friends, in this session, we are going to talk on moral rights. As you know, that today's topic of discussion is rights under copyright law. So, taking the lecture forward, I would like to welcome Mr. Ashwini Sewal once again. Welcome back to this.
Thank you, Geeta. As promised that I'm going to discuss moral rights of the authors. Well, my dear friends, the first and the foremost distinction between moral rights and the economic rights is that economic rights are available to the owners of the copyright. Kindly listen it carefully, that the economic rights are available to the owners of the copyright, but on the other hand, moral rights are available to the authors of the copyright, not to the owners of the copyright. We will understand it further, but let us first see the provision under the Copyright Act 1957, which talks about the moral rights of the authors of the copyright. This is section 57, my dear friends, which talks about the moral rights of the authors, and it reads, independently of the author's copyright and even after the assignment either wholly or partially of the said copyright, the author of a work shall have the right called, which is as follows, that is called moral right to claim authorship of the work and to restrain or claim damages in respect of any distortion, mutilation, modification or the other act in relation to the said work. Well, my dear friends, if you look carefully, that the main language of section 57 reads, independently of the author's copyright and even after the assignment. What does it mean? If I elaborate it a little bit and if I try to interpret it, it reads that even after the cessation of the term of the copyright or expiry of the term of the copyright, or if the copyright term is available to the author, if he has assigned that work wholly or partially to somebody, irrespective of these situations, irrespective of both these situations, what are those situations? If he has assigned it wholly or partially to somebody, or if the author has seized with the right because the term of copyright is over. If he has enjoyed his work, he has passed away, his legal heirs have also enjoyed it for another 60 years. Irrespective of both these situations, you see, there is one more right which lies independently or which remains intact even after cessation of the term and after assignment of the work. That is called author's moral right, which is called the author's special right. Why the moral right is called the special right, my dear friends? It is called the special right because, you see, even after the exhaustion of the copyright, I mean even after the expiry of the term of the copyright, suppose he has completed his term, or maybe he has assigned it to somebody wholly or partially, irrespective of this is a special right which will remain him forever or to his legal representatives forever. That is called the moral right. And what all can one claim, what all the author can claim under the ambit of the moral right? He can claim the authorship of the work. He can claim the authorship of the work. Apart from that, he may go to restrain or seek damages in respect of any distortion, mutilation, modification or other act in relation to the said work which is done before the expiration of the term of the copyright, if such distortion, mutilation, modification or other act would be prejudicial to his honor or reputation. Well, my dear friends, these are the two special rights available or made available here to the author of the copyright. What are those? To claim authorship on the work. Independently of his copyright, what does that mean? Independently of the economic rights available under section 14. Under 57, right to claim authorship, right lies with the author of the work. Right to restrain, seek damages from any person in respect of any mutilation, any distortion, modification done by that person, on the work of the author before the expiry of the copyright of that work, the right to restrain lies with the author of the copyright, and it is a special right. Let me explain it bit further to you by giving you certain examples, my dear friends. I have a very good example to make you understand it, and it is a very popular case in the history of India, wherein, you see, there was a renowned sculpturist, or you can say renowned sculptor. He, at the insistence of the government of India, Union of India, once created one mural art, a huge mural art of long 140 feet in Vigyan Bhavan in the capital of the country, New Delhi, at the insistence of the Union of India, that was made by him. That creation of the sculptor was admired by a lot of people because it was of a bronze made in front of the one hall of the Vigyan Bhavan to beautify that hall, to beautify the Vigyan Bhavan. But after few years, my dear friends, it came to the notice of the sculptor whose name was Amarnath Sehgal that his mural art, created by him by investing 6 long years into the creation of that work at the insistence of the Union of India, is being mutilated or is now being destroyed at the insistence of the same government of India, because government wanted to renovate Vigyan Bhavan. So the huge art, that was a mural painting over there, was posing obstruction in the smooth work of renovation. So they decided to destroy it, and they destroyed it. To restrict that distortion, the author Amarnath Sehgal brought the suit titled as Amarnath Sehgal versus Union of India and sought damages and wanted to restrict the further demolition or destruction of his work. My dear friends, you will be bewished to know that the government of India recognized his special right in the form of moral right, and he was conferred the moral right to claim his authorship on that work. Additionally, he was paid the damages for the distortion, for the destruction and mutilation of his work, which was undoubtedly prejudicial to the reputation of that person, because the person was of very huge repute. He was a person of big repute in the society. He was a renowned sculptor. He was invited by none other than the government of India for creating that work. So it undoubtedly went against the reputation of that person. So he claimed that since the distortion or the demolition of the work had caused prejudice to his honor and reputation, he must be paid some compensation, and he was paid the compensation accordingly by the government of India by recognizing his right. Well, this right, that is called a special right, moral right of the person, is witnessing few changes in today's context, my dear friends. It's still intact and it still lies with the authors of the copyright. They always can claim it. There is no denial to that. But it has seen in the recent history few developments, and those developments are for good and not for bad, my dear friends. I am reminded of one instance wherein in the United States of America, in their National Stock Exchange office, or in front of that exchange office, there is the huge stature of a bull established there by one sculptor. That bull basically demonstrates, represents the vigor and the strength of the economy of the nation. You see, that bull is symbolic of what? Is a symbolic of vigor, strength of the economy of the nation. Recently, there came a controversy notice where another sculptor, who was also a renowned sculptor, my dear friends, created a creation there in front of the bull or the image of the bull of a short-statured girl having a whip in her hand. And if those two statures looked together, it seems that the short-statured girl with the whip is challenging or defying the bull. The controversy arose when the sculptor who created the bull, he went to the court claiming his moral right on his work and saying that I would like to restrict the later creator from continuing to create that small girl having a whip in her hand because it mutilates my creation, and it is my moral right to restrain somebody if somebody is striving to mutilate or distort the work created by me, or if that act of mutilation is prejudicial to my honor and reputation. Since the works, if seen together, are giving a perception that the girl has taken a control on the bull by having a whip in her hand, so the entire symbol or entire message that symbol wanted to convey gets deviated. It wanted to convey the strength and the vigor of the economy, but the whip-handed, the girl having a whip in the hand demeans that or makes it minuscule in front of that whip in the hand of a girl. But the court denied on the rationale that since there is a right of freedom of free expression, it is a fundamental right. So if the later creator is expressing himself, he is free to express himself. We cannot curtail somebody's right of expressing himself or herself freely under the guise of the moral right of the author in the copyright law. I hope you will find it very interesting and you will read it further from different sources. But there is a proviso also attached to this special right called moral right, which we are supposed to read. It reads that provided that the author shall not have any right to restrain of claim damages in respect of any adaptation of a computer program to which clause AA of subsection 1 of section 52 applies. It is a proviso creating an exception in the cases of adaptation of a computer program which are covered under clause AA subsection 1 of section 52, my dear friends. You just refer to that section and you will understand it. It does not require any elaboration from my side. Explanation is also attached there under author's special right, which reads that failure to display a work or to display it to the satisfaction of the author shall not be deemed to be an infringement of the rights conferred by this section. My dear friends, it says that nobody can claim the special right to a situation where somebody has just failed to display a work or to display it to the satisfaction of the author. What does it mean? If I have assigned my work to an assignee for the future exploitation or further exploitation of my work, and if he fails to display that work to the best of my satisfaction, I cannot assert my moral right on this ground, on his failure to display it properly. It is only asserted and it is only enforced when the mutilation, distortion, modification takes place of my work. In those situations, I can certainly assert my special right, that is called moral right. So, my dear friends, we are done with two important things here. We have understood in our previous session the various economic rights available to the owner of the copyright, and we have seen in the beginning of this session different moral rights available or in the form of special right given to the authors of the copyright. Now, as promised, we have come to the next juncture wherein we are supposed to understand the right of adaptation, which is very well a right called economic right of the owner of the copyright provided under section 14, but we have not discussed it in detail. I have brought two cases to discuss what does adaptation mean. It is little ticklish to understand adaptation. That is why I am giving emphasis on this aspect and I am covering it separately. In relation to dramatic work, my dear friends, the definition of the adaptation reads, given under section 2a, it reads, in relation to dramatic work, the conversion of the work into a non-dramatic work is called adaptation. Kindly look it carefully that in relation to dramatic work, the conversion of the work into non-dramatic work, it may be in any kind of a work, but it needs not to be dramatic. So, conversion of dramatic into non-dramatic is called adaptation. In relation to literary work or an artistic work, the conversion of the work into a dramatic work by way of performance in public or otherwise is called adaptation. See, the first part of this clause talks about conversion of dramatic into non-dramatic. The later part talks about, in the cases of literary or artistic work, the conversion of that work into dramatic work by way of performance in public or otherwise. And the third is in relation to literary or dramatic work, any abridgment of the work or any version of the work in which the story or action is conveyed wholly or mainly by means of a pictures in a form suitable for reproduction in a work. It is where we need to emphasize, note and understand what does abridgment of a work mean, because it says that conversion into abridged work of a literary or dramatic work is called adaptation. If the abridged work is conveying wholly or mainly by means of pictures or in any suitable form the entire essence of the work which has been now abridged, my dear friends, it is where I said that we need to give lot of emphasis, because adaptation is what? It's kind of designating or converting one form of the work into another. But within the adaptation, there comes one thing which is called abridgment, and which reads that if you are abridging the literary work or a dramatic work in such a manner which is conveying wholly or the whole substance mainly either in the form of pictures or in some other suitable form to the viewer or to the reader, then that would also be called adaptation of the work. Let me make you understand by taking one example from one case law, my dear friends. I have a very old case to make you understand this aspect. There is one case called Macmillan versus K&J Cooper. It is Macmillan and Company Limited versus K&J Cooper of 1924. It is a case on abridgment, and it is a very celebrated case to understand the law of abridgment, my dear friends. I have just emphasized that abridgment is adaptation only, but in the case of the abridgment, the sine qua non is that one who is abridging the literary or dramatic work, he is conveying wholly or the main substance of the work in the form of the pictures or in any suitable form. But the main work must get conveyed. If somebody is not conveying the main work by abridging the literary or dramatic work, then that person cannot claim to be the owner of that work. No copyright can be conferred on that work. So let us first at the outset understand that suppose there is a work, by an example, that suppose there is a work which is in the public domain, and that has been now referred by one interested person and has been taken by one interested person. He wants to concise that work, and he has, by his brain work, by his skills, judgment and labor, has reduced the length of that work which was publicly available. Will that person who has, by referring to that work, reduce the length of that work, be getting the copyright protection? My dear friends, the law says, since the work was in the public domain, nobody was owning the copyright on that. The later person who has referred that work and had abridged it will get the copyright protection on that abridged work if he had conveyed wholly the main substance of the work by concising it. But by mere reducing the length, or by merely concising it in length, or by mere, reducing the length by omission of certain paragraphs, certain portions of the work, or by just, attaching few detached paragraphs, by addition of certain words to give a consecutive narrative to the work, the person will never be able to get the copyright on that abridged work. The case law which I wanted to discuss here is Macmillan and Company versus K&J Cooper, my dear friends, of 1924. In this case, there were two works in contention. Those two works were basically created by referring to one work which was available in the public domain. The work which was available in the public domain was the work of Sir North's translation. On the basis of this publicly available work called Sir North's translation, two works were created. One was titled as, or was given the name by the appellant here, Plutarch's Life of Alexander. Another work was given the title Plutarch's Life of Alexander the Great by the respondent. Both the works here are the creations from the publicly available work, my dear friends. It is allowed to refer to a publicly available work without the authorization of the owner of the person and to reproduce it. But to what extent one can reproduce it and claim copyright on that, it is questionable. In both works here, my dear friends, the controversy arose because the appellant, the owner of the first work called Plutarch's Life of Alexander, instituted the legal action of copyright infringement against the respondents who were claiming to be the author of Plutarch's Life of Alexander the Great. If you look at the format of the works of respective parties here, the appellant said the work, which was basically the conversion of the publicly available work Sir North's translation, the outcome which was called the Plutarch's Life of Alexander, was reduced in the length from 40,000 words of the original work to 20,000 words by, as they claimed, since they claimed, by their brain work, labor, skill applied by them. Similarly, the respondents were claiming that they have also reduced the length of the original work of 40,000 to 20,000, and they have added their 7,000 additional words into their work. So the copyright infringement suit was instituted, but the court was first had to decide. Court was basically, in the question to decide as to whether this work is copyrightable or not, and whether the appellants who are claiming themselves to be the authors of this work, are they the authors of this work or not? This was the moot question revolving in that case. Since the work was taken from the Sir North's translation work and it was an abridged work, can the owner, by merely abridging the length or reducing the length, get the copyright? It was the moot question. And if he can get the copyright, he may be conferred with the copyright protection and can easily be successful in restraining the respondent from using it further. So we have to understand that abridgment is a part of adaptation, and we have seen the fact sheet here. Now I will be quoting the textbook of Coppinger's Law of Copyright, which is one of the prominent textbooks available on the subject, which reads on the law relating to abridgment that to constitute a true and equitable abridgment, my dear friends, the entire work must be preserved in its precise import and exact meaning. If you look at the first part on the screen, it reads that to constitute a true and equitable abridgment, or to claim the right on the abridged work must preserve in its precise import the exact meaning of the original work. If the exact meaning of the original work is not getting conveyed wholly, or the main part of the original work is not getting conveyed wholly, then the act of the abridgment will not be able to get the copyright to you. This is what it writes. And then the act of abridgment is an exertion of the individuality employed in molding and transfusing a large work into a small canvas, thus rendering it less expensive and more convenient both to the time and use of the reader. These are the beautiful, portions of the textbook on the law relating to abridgment, which reads that to claim the right of copyright on the abridged work, the person doing the abridgment must prove that the whole sense of the work is getting conveyed first of all, and he needs to further prove that individual efforts have been made or exerted in molding and transfusing the large work into a small canvas, and thus rendering it less expensive and more convenient to the reader in terms of time and use. So one who has been able to precise the work, concise the work, abridge the work by conveying its or portraying its, sense or the essence of the work wholly, or the main substance of the work wholly, by transfusing it into a small compass with the efforts made by that person, with the brain work done by that person, with the creativity applied by that person to make it more, user friendly, then the person may get the copyright protection. But if he had just reduced the length and he has just omitted certain paragraphs, or some paragraphs have been rearranged, or some additional words have been added between two detached paragraphs to give the consecutive narrative to the work, then undoubtedly the person may not getting the copyright on that work. Well, my dear friends, I rest here because I believe this discussion will be very helpful for all of you to further develop the law on rights of the copyright owner. Thank you very much.
And we would like to thank Mr. Ashwini Sewal for giving us a productive session once again. Friends, if you want to see this lecture the number of times you wanted, then watch this lecture on YouTube, as we are going to upload it on YouTube, where you can see all the other lectures pertaining to this series, that is on copyrights and trademarks. So we would be meeting again very soon and would be discussing on another topic. Till then, take care. Goodbye. Thank you. So thank you once again.